Exactly the time that we could start the panel discussion. So thank you very much, keynote speakers. You will be staying for the panel, so we will have probably a few more questions to you. But first, in the panel discussion, we have a member of parliament in Switzerland, Mr. Fabian Molina, who is unfortunately unable to attend this conference, but he sent this video message for us to see. So if I could first try to show this as the first list.
I'm not able to attend the panel in person.
Oh. Sorry.
Dear Professor Kihara-Hunt, dear ladies and gentlemen, my name is Fabian Molina. I'm member of the Swiss National Council for the Social Democratic Party and co-chair of IPEC Switzerland. Firstly, I'd like to thank Professor Kihara-Hunt for the organization of the panel. Unfortunately, I'm not able to attend the panel in person, but it's a pleasure, though, to send you a short summary about the state of the Magnitsky Act in Switzerland. I suppose I don't have to explain why the implementation of a Magnitsky Act would be an extremely important progress in acting against serious human rights violations and corruption by high-ranking politicians. But let me start by pointing out the state of the Magnitsky Act in Switzerland. In late December 2019, I handed in a parliamentary intervention demanding Parliament to introduce a legal basis in order to sanction high-ranking and corrupt politicians. This would give the Federal Council, our government, the authority to impose accounts and travel bans on high-ranking foreign politicians who have committed serious human rights crimes or are involved in serious cases of corruption. Such measures would be limited to 2 years with the possibility of a one-time extension. In case of complaints against these measures, an independent ombudsman's office would have to be set up. At the latest, since the Second Iraq War, we know that comprehensive economic sanctions affect a country as a whole and can have significant negative humanitarian impact on the civilian population as well as on third countries. Accordingly, Switzerland played a leading role in the so-called Intl process, in which, on behalf of the Security Council, the concept of smart sanctions was developed, which specifically sanctions only individual high-ranking officials which have committed a crime. According to the UN Charter, the international community as a whole has a responsibility to contribute to the observance of each state's obligations under international law to protect the human security of its citizens. Several countries have now implemented this concept in their national law. The most now example is the known example is the US-American Global Magnitsky Human Rights Accountability Act. In Switzerland, there is already a legal basis for measures in the case of human rights violations and corruption crimes. However, all these legal sources have crucial gaps in comparison to smart sanctions. For example, it is not possible to react politically to serious violations of the international legal system. Numerous examples of recent foreign policies reveal the existing legal shortcomings. Without sanctions decided by the UN Security Council or the EU, Switzerland has hardly any possibilities to react to serious events or must resort to extremist measures in order to sanction them. The introduction of clearly defined targeted sanctions can remedy this shortcoming. The Foreign Affairs Committee has approved my intervention. In the coming weeks, the Senate will discuss my intervention, and I'm confident to find a majority in order that Switzerland implements a Magnitsky Act. Lastly, I'd like to point out an argument that is very important to me, and which you may already have discussed. Introducing a Magnitsky Act in national law is highly important. However, I'm convinced that intergovernmental organizations should push along a multilateral solution. A legal basis for multilateral UN sanctions would put more pressure on states who violate human rights. I hope that an international solution will be found soon. And now, I wish you a good discussion, and I hope to be able to join the next panel with you. Greetings from Bern.
Okay, very sorry about the sound. So that was MP Fabian Molina from Swiss member of National Council and a member of the Social Democratic Party and a co-president of Swiss Aid. He is behind this Magnitsky law in Switzerland. Okay, now if I could introduce the panelists. So we have 3 keynote speakers whom I've already introduced, and we have Mr. Simon Henderson, who is the head of policy at Save the Children Australia, and with an experience in government and NGOs and industry bodies in Australia, Hong Kong, and US. He's an expert on international human rights law, and he works in policy advocacy. He's also a lawyer of the High Court and in Australia and in Australian Capital Territory. He's been involved in discussion in human rights issues, including on Magnitsky law. So that's Mr. Simon Henderson. Can I also introduce Paul, Mr. Paul Namkoong, if you can put him on there as well. Yeah. So he's from our own international law training and research hub. He's been behind this research for this symposium, and he's the creator of the Magnitsky law infographics that all the participants have hopefully received, unless your inbox was full. We have 2 additional panelists, and you can also put the keynote speakers on. Thank you very much. And Lady Kennedy. Okay. So if I could start with Mr. Simon Henderson, because I think we heard a lot about the US, Canada, and the UK and the global movement. But I would like to ask you to have your intervention on how it was in Australia, including how the discussion was initiated, what was the discussion points, the point of contention, how you pushed for it, what were the challenges. Maybe I shouldn't limit what you would say. Share experience in Australia.
Thank you very much, Professor, and can I just extend my thanks to you and to the University of Tokyo and Human Rights Watch for convening this event. I greatly appreciate you inviting me. So in terms of Australia's position, it's helpful to give a little bit of a context to sanctions laws in Australia. Australia doesn't have Magnitsky sanctions yet, but we already have 2 sanctions pieces of legislation. So we implement UN Security Council sanctions under the Charter of the United Nations Act, and we also have an autonomous sanctions regime under the Autonomous Sanctions Act of 2011 and Autonomous Sanctions Regulations 2011. And the Autonomous Sanctions Act, which was introduced in 2011, was largely in response to a recognition, which many of the panelists and keynote speakers have talked about today, that existing accountability mechanisms were not proving to be effective, especially through the UN Security Council. So the Autonomous Sanctions Act defines an autonomous sanction as being as a tool to influence foreign government policy, a member of a foreign entity or another person or entity outside Australia. So Australia has used the Autonomous Sanctions Act to impose financial sanctions.
Sorry, Mr. Henderson. I think there are a little bit of distortion in the sound. I can hear.
My apologies.
Hear, but I'm wondering how it can be improved. Is it?
My apologies. Can you hear me more clearly now? Is that better? Or is it still distorted?
We can hear you. It's a little bit like a robot. It's a little bit robotic.
Apologies. Do you want to go to another speaker for a moment and maybe come back to me, and then I'll try and fix my mic in the interim if that's okay.
Okay. If you could try, yeah, we can hear you, but yeah, okay. So maybe while you are trying to reconnect or to try to sort out the sound, maybe then I can ask Paul, if researching on these Magnitsky laws in the world and listening to all these leading Magnitsky law activists and people who made this happen, what are the main lessons learned, you think, from this Magnitsky law in various countries, and how do you see fit? So do this fit in Japan?
Okay, yeah, thank you for the question. So I'd say that in the time that I kind of spent looking through documents and journals and articles about these laws, I probably took away 3 major points. So I think first, and it's something that maybe wasn't addressed, directly by the keynote speakers, like there's a lot of questions about would these sanctions actually be effective in deterring human rights violations? And a lot of the research currently, or a lot of this discussion, shows that it's already far too early to quantitatively assess the effectiveness of Magnitsky sanctions, and deterrence is inherently hard to measure. And in addition, targeted sanctions programs, they tend to focus on a very small set of offenders. So the sample size is not large enough for Magnitsky sanctions yet. But we can still look at, I think, previous assessments of individual targeted sanctions. The UN has released a lot of reports about its individual anti-terrorism sanctions or financing terrorism sanctions, and there's a lot of research done on that. So I think there's a few key points to absorb from those. So one of those would be that individual sanctions, they don't outright shift regimes, and I think we all know that, but they deter members of inner circles from doing or committing like the worst offenses or their worst behavior. And there's a lot of examples to kind of attest to that. So the keynote speakers kind of mentioned a lot of prominent examples, but I'll try to include some others. So Belarus's opposition leader, Andrei Sannikov, a few years back, I think, testified in 2016 to saying that he was imprisoned on false charges of organizing mass disturbances. But he kind of said the only proof or the only reason that he's alive today was because the government officials released him, and they openly discussed in front of him that they were scared of having sanctions applied to them. So again, these like human rights sanctions have a noted effect of deterring the worst and most public human rights violations, and we can kind of see that starting to happen with Navalny in Russia as well. So we'll kind of wait to see what happens. But Amal Clooney, I think, in an Australian subcommittee hearing, also mentioned that the president of the Maldives was imprisoned on false charges, but the prospect of sanctions being imposed on individuals responsible also led to his release. So simply put, it makes life extremely difficult for officials who've been sanctioned. They're named and shamed. they lose access to international finance, and they can't send their children to school in those countries. So I think Bloomberg News also reported that Carrie Lam had to literally carry around bags of cash because no banking service would accept her money after she was hit with Magnitsky sanctions. So again, this just kind of points to the extreme difficulty for people hit with sanctions to live a normal life, and that's a serious deterrent for human rights violations. So banks who also do business with these individuals and companies face sanctions, and so it really creates this pressure to also align businesses with human rights principles.
Thank you, Paul. I think maybe Mr. Henderson's microphone is fixed now. So would you? We heard about the UN Charters Act and how you were introducing Magnitsky Act, but if you could continue from there.
Thank you, and apologies. Can you hear me clearly now?
Yeah.
Thank you very much, and my apologies for that. So, as I was saying, Australia has two sanctions pieces of legislation, but the problem has been with the Autonomous Sanctions Act is that it is not fit for purpose in terms of lacking flexibility and precision, and it has had numerous deficiencies. So there are a few problems with the autonomous sanctions regime. Firstly, it fails to target human rights abuses, including violations of international humanitarian law and corruption. The Act itself fails to mention human rights. It was only ever included in the explanatory memorandum, and there's no reference to corruption. And where sanctions have been applied, for example, in the case of Zimbabwe or Syria, there's a lack of information as to what form of human rights abuses are being targeted. Secondly, there's a lack of information about criteria and evidence that are used to apply autonomous sanctions. And this makes it quite challenging if you're a government official to undertake an assessment or for the decision maker to determine what criteria to follow. Thirdly, there's a lack of civil society engagement in the process. There is no role for civil society engagement in the administration of sanctions under the autonomous sanctions regulations. And that is a particular difference to what we see in other jurisdictions, particularly in the United States. And finally, there is no parliamentary oversight under the existing Autonomous Sanctions Act. That it lacks mechanisms for reporting or review through Parliament. So what has happened in Australia, there have been attempts at various times, notably in 2018, there was a private member's bill that was introduced by Michael Danby that lapsed when Parliament was dissolved in 2019 when an election was called. And we've had a resurgence as a result of a parliamentary inquiry, which previous keynote speakers have talked about. And that inquiry commenced at the end of, was called by the Foreign Minister at the end of 2019, December 2019. And a large part of last year was substantial engagement from civil society, academia, lawyers groups around the proposed development for a new sanctions, Magnitsky sanctions law in Australia. And in December last year, a report was handed down which called for the development of a new standalone sanctions regime, which is what a lot of civil society organisations are calling for. So we're now in that process of waiting for the government response, and there will be next steps around what that government response will look like, potential drafting of the bill, and certainly a good deal of discussion about comparisons with other jurisdictions.
Maybe just one more question to Mr. Henderson. What is the point of a disagreement, or what is the when you are trying to get together civil society groups to push for this? Is there any disagreement among civil society groups, and what is the what would that be?
Yeah, I think it's a really good question about potential disagreement among civil society groups. And I note one of the questions in the chat box earlier was around what about the role in a humanitarian context and the role of sanctions in a situation like that. And Save the Children, as well as being a child rights organization, we're a humanitarian organization, and we operate in conflict environments. And we need to ensure that we are still able to access humanitarian situations and respond appropriately to protect children's needs. At the same time, we want to ensure accountability for human rights abuses. So it is really important that when Magnitsky laws are being drafted or sanctions laws are being drafted, that there is a very clear provisions around what the provision of humanitarian assistance is. So in the autonomous sanctions regulations in Australia, there is reference to humanitarian assistance, but there's no details as to what that might include. And so a submission that we circulated, and I think might have been sent out to the group, it talks about the case of North Korea. And ensuring that if there are going to be exemptions that are granted, that we're very clear about the language that is used and also the naming of individuals, the naming of corporations and entities to ensure that there are not unintended consequences. So we can still tackle humanitarian access and ensure accountability of human rights abuses at the same time.
With regard to those points that Mr. Henderson has brought up about the challenges, about the act that is targetable, about the lack of information, about the civil society engagement, would the keynote speakers have, in comparison to Australia, would you have any, difference, comments, your assessment of effectiveness in your case? Maybe should we start with Mr. Browder?
Hi. Yeah. It's when you look at the effectiveness of any policy, you can look. It's kind of hard to study what somebody might have done if the policy wasn't there, that didn't do with the policy that was in place. And I had an absurd conversation early on at the EU after the Russia invaded, or took Crimea, invaded Ukraine. I went to the EU to push them on doing Magnitsky sanctions as well as sanctions on Ukraine. And the officials in the EU, this was back in like 2015, 2016, the officials at the EU said that our sanctions policy is designed specifically to alter behavior. And so they said, there's no way we can do Magnitsky sanctions because we're now looking at the Ukraine sanctions and saying, because they haven't withdrawn, we're thinking about releasing them from sanctions. So they haven't, of course. We're now 2021 and Russia is still under sanctions. But I listened to the stupidity and I thought to myself, you can't just look at what Russia did. Did they not withdraw and therefore you should release them from sanctions? No, you have to say, what might have they done if those sanctions weren't put in place in the first place? And I would argue that if the Western world hadn't sanctioned Russia over invading Ukraine, they might have already gone to Kiev by now, which they didn't do. And so, coming more specifically to the Magnitsky Act, we know it works because of how mad everybody is who gets put on the list. As I mentioned, Putin went out of his mind, but it's not just Putin. Everybody who gets put on that list goes out of their mind, because when you get added to the Magnitsky sanctions list, you basically become a financial pariah in the world. Every bank closes your account. And as was mentioned before, Carrie Lam, it was great, that the interview with Carrie Lam, where she said, I don't care about sanctions. So what? So what if HSBC closed my bank? I now keep my money in a shoebox in my house. Well, guess what? I would imagine that there's a lot of burglars who are watching that show thinking, okay, that looks like a pretty good place to burgle. Of course she cares. And of course, everybody who gets put on this list cares. And of course, and it's not just the people who get put on the list that care. It's everybody else who didn't get put on the list, who thinks they might get put on the list. And after the Khashoggi murder, and after everybody started talking about sanctions against Saudis, I was actually at the World Economic Forum in Davos, and I was approached by a Saudi business journalist who said, there's an absolute panic going on among the business elite in Saudi Arabia, wondering who's going to get sanctioned. And I know that the same thing is true in Russia, that every time there's a big sort of atrocity committed by the regime, all of the oligarchs are worried about them being sanctioned. And so this has an enormous effect. And the last thing I would say, and this is really important, is that even if you couldn't measure any of these effects, even if you couldn't measure what they've done in response, or they couldn't measure what they didn't do, which they might have done, it's obvious that if in a world where there's no consequences to doing bad things, people will do more bad things than in a world where there's consequences of doing bad things. It's just plain simple logic. You know, if you create a punishment for bad things, and that punishment is real, which the Magnitsky sanctions are, then some people will refrain in doing bad things. It's just simple logic, risk reward. And so I don't think that it probably shouldn't even be a question whether these sanctions work, because it's so obvious that they do. But more a question of how we get more people added to these sanctions lists.
Yeah, thank you very much, Mr. Browder. Can I invite Professor Cotler? I will just unmute.
Yes, as I mentioned, we experienced an important parliamentary role in the adoption of the Magnitsky sanction legislation, and important civil society engagement. But since the legislation has been adopted, the government has become the principal actor. It is the government who determines who will be sanctioned. And at this point, there's no built-in institutional role, neither for Parliament nor for civil society. And I think one of the things we need to do in the Canadian experience, and I suggest this for Japan and considering it, is that we need to build in a parliamentary role, both in who will be sanctioned and also a parliamentary role in the oversight of the process. It's somewhat ironic that Parliament was such a principal actor in the adoption of the legislation, and the government was sometimes reluctant to do so. And now that the legislation is adopted, it's left to the government to make that determination as to who will be sanctioned, with Parliament having more of a passive role in that regard. So I think that needs to be built into the framework of the legislation, as well as to have a civil society involved. Otherwise, we may find that it's the executive branch which is leading or not leading the way, without enough parliamentary and civil society involvement.
Thank you very much, Professor Cotler. So could I ask Baroness Kennedy?
I couldn't agree more with Irwin Cotler. It's absolutely right that we made the same mistake in that when this legislation went through, we were new to it, and our system, of course, is different from that of the United States, and so we didn't think through how it might be very much in the hands of the executive and almost invisible. And that's the one, the area where I think that we got it wrong. I would advise that any other nation should try to build in, first of all, parliamentary oversight, a greater transparency, and some way, in some sort of actually established way of giving access to NGOs and to the wider community in expressing their views as to the steps that government should be taking. And that currently isn't happening. I mean, it's happening in that there is lobbying, and there are people who kind of get up on their feet regularly in Parliament and say, why aren't we putting more of the people in Myanmar on the list? But we're not included in the actual decision making in the way that perhaps you could in creating legislation. Adopting Magnitsky law could actually weave it more into your system, into your parliamentary system.
Thank you very much, Baroness Kennedy. I think Yes, we can probably we can have this panel without with Miss Doi Kanae-san, because we had this panel discussion and Q&A, but it's in fact a very active involvement of the participants, and now it became Q&A. So maybe I can hand over as it is to Doi-san, so that you can continue from here, and maybe you can also ask Mr. Henderson about the civil society engagement that I couldn't ask at the end.
Thank you very much, Professor Kihara-Hunt, and thank you very much, panelists. Once again, my name is Kanae Doi, so let me just take over. But I was supposed to work on Q&A, so if there are any people who wants to put more questions, I mean, please go ahead. I'm happy to take those from you. So I'm a civil society activist, and then together with others, I have the kind of heavy burden to encourage Japanese parliamentarians to push Japanese version of Magnitsky law to be passed. I cannot pretend that this is an easy job. As you can see, that Japan has been the softest among the G7 countries on I would say almost every human rights issues around the world, except for North Korea. So here, of course, I want to hear from everybody, of course, particularly from Mr. Henderson, but because you are in the same position like myself, but also all other panelists. What's the key challenges you faced when you try to introduce? I mean, you have already talked about that, but if you can highlight, and then you can give advice to me, but also I would pass on this advice to the parliamentarians, Japanese parliamentarians who are pushing this, who are taking up this very uphill battle in Japan. What's the key challenges, and then what's the kind of creative ways or whatever ways you address the key challenges in passing the laws, and then what's the advice you have to civil society activists like myself in Japan, and also MPs in Japan. Can I start by Mr. Henderson, and then I would like to hear everybody if you have any advice.
Thank you very much for that, and maybe I'll focus on one particular challenge that we've seen a lot in Australia, and that is one of resources. So whenever we speak to government officials, and I myself used to work in the Ministry of Foreign Affairs in the Australian government, the challenge is always about resources. So how are they going to implement a new sanctions regime? Where are new staff going to come from? How are they going to be able to write reports? That's always front and centre of their mind. And we have a look to the Australian Parliamentary Inquiry and the Department of Foreign Affairs of Trade of the Australian government. Their submission highlighted those particular challenges. How would they be able to respond? So from a civil society perspective, how have we dealt with that? Well, to begin with, we've developed really close relationships with embassies and high commissions in Australia, particularly with the US Embassy. The US government sent out representatives who were involved in sanctions legislation to Australia excuse me, pre-COVID, and they visited Australia in January of 2020. And that was really helpful because they were able to meet with Australian government officials and talk about the policies and responses. And those conversations have continued to this day, and we continue to remain in quite close consultation. The other part in terms of resources and constraints is we've been able to talk about how can civil society help government in terms of providing designations. So in many cases, any government might have a strong presence overseas and might have a diplomatic mission, but civil society will have much stronger networks. Whether you're an international NGO, grassroots NGO, diaspora communities, you might have a much better understanding of what's going on the ground and how these human rights abuses are really impacting most vulnerable people. So being able to explain as to
for how you can support government in the provision and preparation of information that would involve briefs that is providing advice to a minister, I think is really valuable. So forming those connections with government, engaging with other foreign governments where there are those missions, and talking about the valuable role of civil society. That would be one of my really strong pieces of advice.
Thank you very much, Mr. Henderson. Yeah, I would like to ask any of you, Mr. Bill Browder, Ms. Kennedy, Professor Cotler, I mean, whoever wants to start.
I'm happy to start, or unless anyone else wants to go ahead of me. The my experience has been that the main opposition to doing this, similar to what Simon was referring to, is the what I'll affectionately refer to as the deep state. Basically, so if I go to a new country, like Japan or like any place, it's a nonpartisan issue to say, should we or should we not allow torturers and murderers and kleptocrats from coming into the country? Everybody has the same, every politician has the same response, which is, of course, we shouldn't allow them, and we shouldn't allow them to use our banking system and keep assets here. That's kind of an obvious, clear, no-brainer. So then it's, and nobody is going to lose a vote. Nobody's not going to be get reassigned their party to their party list for taking that position. And so that's kind of an obvious thing. So where does the problem arise? There's two places where the problem arises. One is that you'll have some lobbying from China or Russia or some other bad countries, and as Irwin mentioned in his remarks, the Russian government tried to put pressure on Canada not to do the Canadian Magnitsky Act, which of course blew up in their face with a unanimous vote. So that's usually not that effective. But what's remarkably effective and highly frustrating in every country I've ever been to is the power of the bureaucracy in trying to make sure it doesn't happen. And why does the bureaucracy want to make sure it doesn't happen? I think there's some, resources, as Simon mentioned, is one part. But part of the reason they don't want it to happen is that every foreign ministry is kind of in the business of keeping relations smooth and sweet with every country, no matter how good or how evil. And nobody wants any trouble. And so they're the ones who have to, the moment that someone's sanctioned, they're the ones who have to take the phone call from the foreign minister of the other country, complaining and screaming and demanding and so on and so forth. And so they're the ones who just want to have a simple, quiet life. And by inserting this, we make their lives not quiet. We give them a problem. We're giving them a problem that every day is difficult. And so they're the ones we have to overcome in this story. And the trouble is they're the ones who both have to effectively put the legislation in place, and they're the ones who have to implement the legislation. And so it's a tough job. And as Helena and Irwin have both said, if they have their druthers, they'll not do something. And that's exactly what's happened in Canada. Since 2018, Canada has not used the Magnitsky Act. And so we do need to create a situation where there's a formal pressure mechanism coming from parliamentary oversight. There is an existing mechanism in the United States. There's something called the congressional trigger. And the congressional trigger says that if the chairman and ranking member of certain committees, like the Foreign Affairs Committee, the Intelligence Committee, the Security Committee, call for someone to be sanctioned under the Magnitsky Act, that the government has 120 days to formally respond about whether they've sanctioned that person or whether they have not, and their reasons for either sanctioning them or not sanctioning them. It's a great principle. It's actually been tested unsuccessfully during the Mohammed bin Salman Jamal Khashoggi story, where the ranking member of the Foreign Affairs Committee and the chairman called for Mohammed bin Salman to be sanctioned, and then 120 days later, the State Department didn't respond, and I do know that the Open Society Institute has sued the State Department to try to get them to respond, and the lawsuit was, I think, partially successful in getting information. But it's a hell of a lot better to have this congressional trigger, even if they abuse it, than not having it at all. And so I was just texting Helena during this thing about that we need to work on a UK congressional trigger, and we will, and I am, and I think she will with me. And Irwin, it would be great if we could find some way of legislating a Canadian congressional, parliamentary trigger, so that, or some oversight, so that this this dereliction of duty of the Canadian government since 2018 is not allowed to progress.
I would like to. I'd like to comment on this too. Oh,
go ahead, Helena.
I cede to you, Irwin. Yes, I just want to talk about what Bill has referred to as the dark state. I've had a number of those experiences where, as a parliamentarian, I've gone to meetings with persons in government, along with attended by people who are part of perhaps our intelligence, part of our overseas remit, or even just the civil servants who service our Foreign Commonwealth and Development Office. And the difficulty is they always think that they can do things behind the scenes, slowly catchy monkey, that stuff. And so I mean, I've said it publicly. We had that problem with Iran over the Nasreen Radcliffe, a woman who is an Iranian who's married to a British man, but she's been through a most terrible time of false allegations of espionage and thrown in jail, and they've used her as a pawn in relation to the UK. And when that first happened and she was first arrested, her husband met with me, and then I took it up with the Foreign Office. And their starting point was, please, don't rock the boat. We're in the business of negotiating this. Don't go public, Baroness Kennedy. Don't please tell Mr. Radcliffe to go quietly. We will get this sorted behind the scenes, and so on. And so we sat tight and quietly, waiting for this magic to be done. And of course, the woman, years and years later, has been in prison, has been on the verge of nervous breakdowns, has had physical detriments to her health, seriously, separated from her child, playing cat and mouse, allowing her home to her parents with an ankle alarm on her, just to recover her health well enough to bring her back into prison, bringing new charges when, the most disgraceful abuses of human rights. And I still grind my teeth over the fact that we were told to be quiet in the early stages, because perhaps if we had gone in hard then, we might have got a better result. The same thing in relation to China. With regard to our trying to put an amendment into a trade bill, would have declared that a way of declaring that there was a genocide taking place against the Uyghur, and we met with the minister, and there in the meeting are persons who are from that bit that Bill has called the dark state, saying no, we can do behind the scenes and have conversations and so on. And all I can tell you is those conversations come to naught. And so I feel very strongly that we have to introduce other mechanisms to try and urge this along the road, because the old ways of doing things haven't been that successful.
just to follow up, and it connects with what both Bill and Helena said. We went through 3 phases, as I mentioned. The first is we started in 2010, and at that time we just had to raise awareness of what the Sergei Magnitsky case and cause was all about. It was not a household word as it is today. And so we had hearings then before the Foreign Affairs Subcommittee. We showed a film documentary on Sergei Magnitsky. Bill Browder came repeatedly to Canada, and along with Boris Nemtsov. And that first phase, there's one thing I didn't mention, which I think was a dramatic moment when Boris Nemtsov was asked in a press conference, isn't this the Sergei Magnitsky legislation, isn't it anti-Russian? And he said, no, it's the other way around. He says it's pro-Russian. It's pro the Russian people. It's legislation on behalf of the Russian people. It's to bring justice for the Russian people and accountability for the violators. And that I thought was a very important moment. The second phase was when we moved to global justice for Sergei Magnitsky legislation. That was in 2015. That was galvanized by the assassination, tragically, of Boris Nemtsov. And here, Parliament became the principal actor, joined by civil society. The government, as I mentioned, was reluctant. What became a game changer was the appointment of Chrystia Freeland as the Foreign Minister of Canada. She had had foreign experience. She had been a journalist. She had been a civil society actor before. And so she joined hands with the Canadian parliamentarians and effectively brought in the executive branch of government along with Parliament and civil society. And that was led to the adoption of global justice for Sergei Magnitsky legislation, unanimous votes, etc. But then Bill mentioned, since 2018, very little has been done. And I'll just close to show how Parliament has remained active, but has no institutionalized role. But the government remains less active along with the deep state. I'll give you one case study. Last July, the Foreign Affairs Subcommittee on Human Rights, the one that began the whole Magnitsky process, held hearings with respect to what was happening to the Uyghurs in China. It held 2 days of intensive hearings. It then reported out unanimously, all party recommendation that, among other things, there should be targeted Magnitsky sanctions because what was happening with regard to the Uyghurs was a genocide. So we had the first ever parliamentary determination that it was a genocide and a specific recommendation to target those involved in it for Magnitsky sanctions. Nothing happened from that. Then came very recently, the Parliament of Canada became the first parliament in the world to make a determination that what is happening to the Uyghurs is a genocide, and subsequent to make recommendations for Magnitsky sanctions. The government has said that it is still examining as to whether a genocide has indeed occurred and whether they will move in that direction with regard to Magnitsky sanctions. So what comes out of all of this is a need to institutionalize, as we said, the role of Parliament, the role of civil society, so that all the players, government, Parliament, civil society, have an institutionalized role, and that can activate the process and make it more effective and accountable and transparent, as Baroness Kennedy said.
Thank you very much. Very good advice. And then, but this brings me to the next question. In fact, currently, as I said in my opening remarks, that there are a few, some Japanese lawmakers led by Ms. Shiori Yamao and also Gen Nakatani, who are the IPAC members as well. They are the ones who has produced a kind of outline of the bill, which contains the congressional, or I would say the diet trigger, which I think is a very good news. And I learned from you that this is very important. And then also parliament oversight is very important. And then in particular, from my experience working with the Japanese foreign ministry for the past 20 years, they are very, very, very reluctant to speak up. Of course, they are very, very reluctant to sanction any grave human rights abuses. So congressional or the Diet involvement is, I think, essential in Japan. So it was very good advice. But on civil society, institutionalizing civil society involvement, what kind of, system do you recommend to us from your experiences or from your, any insights? Welcome from any of you.
Let me just say that the best practice for civil society involvement in getting people sanctioned is an unbelievably great organization in Washington called Human Rights First. Human Rights First, their Magnitsky sanctions program is led by a man named Robert Brzezinski. Robert Brzezinski was previously, before 2016, in the Obama administration in the State Department, and he was the Deputy Assistant Secretary of State in Human Rights, responsible for global Magnitsky sanctions. And so he left, and he now coordinates, and his organization is responsible for a third of all people who have been sanctioned under the Global Magnitsky Act in the United States. And he now operates with almost in public-private partnership with the State Department in coordinating submissions so that the government knows, or I should say that victims understand the standard of proof that needs to be presented, and the government ends up getting properly organized sanctions packages. And so I would encourage you and others to study or contact, and they're fully open and transparent and inclusive, Human Rights First. And I know, in fact, their thing has been so successful that they've now almost created a franchise. Now, an organization called Redress in the United Kingdom has taken on their role to do this in the UK. And I understand that I think Transparency International is going to be doing the same thing in Europe. And so it's really an important lesson that they've learned, and everybody can learn from their experience.
Just to follow up that with regard to Canada, I want to second what Bill said. Our Raoul Wallenberg Center for Human Rights is probably the leading civil society organization in the advocacy with regard to a Magnitsky regime. We are in touch with Human Rights First, and they are the gold standard in this regard. And as Bill said, they've developed a public-private partnership, which is a model not only for process, but for effectiveness. And we are trying to effectively develop the same approach in Canada. We don't have anywhere near the resources that they do. One of the things we have done, which I think is helpful, is we established within our Raoul Wallenberg Center for Human Rights, as I mentioned, a Raoul Wallenberg all-party parliamentary caucus for human rights. And that meets at least 4 times a year. And the issue of Magnitsky sanctions is an ongoing present item on the agenda. But again, we can keep it engaged in the parliamentary sector, but we need buy-in from the government, and we need buy-in in terms of the institutionalized role of parliament. So we get back to the same issue, and that's why with regard to Japan, I think it's very important in the adoption of that legislation to build in an institutional role for parliament, build in an oversight role, build in transparency, and build in a civil society contributory role.
Nae-san, I'm very sorry to intervene, but there seem to be quite a lot of questions coming in chat, and I'm wondering if you can pick up maybe one because of time.
Yeah, okay. Yes. So one thing, I know that the time is running, so the last question, I would like to choose the question about business. There are a few questions related to, I think, business. One is that the question is about business should be against, or the very skeptical, or often very much against the fast introduction of Magnitsky-style laws, but also sanctioning, individuals and companies. So, and do you? What's your experiences about with the business? And then, if you counter any, strong push against, putting on sanctions or introducing the laws, how have you addressed those oppositions? Japan is a big business country, and then I hear a lot of concerns that the business would be the one who would oppose the introduction of such a law in Japan. So if there are anyone who can answer this question. But also, sorry, another question was from someone in the Japanese business who wants to support this kind of move. So if there are any companies who are mindful about the SDGs or ESGs, and then who want to help this movement, what companies can do? That was another question. So if there are anyone who are willing to address these company aspects,
yeah,
please,
I can do it. So,
thank you.
As a businessman, I can address them very clearly.
Sure.
No business will openly support a Magnitsky Act for the obvious reason that they don't want to alienate any government that they're doing business with. And it's really remarkable, watching, after the Saudi Arabian murder, after the MBS murder, that people continue to show up at his, all sorts of really important business people continue to show up at his Davos in the desert. The guy is a cold-blooded murderer with literally blood on his hands, and that all these business people would show up at his big conference because they're all trying to get money from him. Or even more shocking, there was a movie about him, a really excellent movie done by Brian Fogel, who was the Academy Award-winning director of Icarus, which exposed Russian sports doping. And he exposed, he basically has created a movie which convicts Mohammed bin Salman. And as an Academy Award winner, you'd think that somebody would want to air his movie. And Netflix, Amazon, Hulu, nobody would touch him because they're all afraid of the business consequences. So that's the bad side. The good side, and this is very important for you, is that no business in this world that we live in particular wants to be on the record in any way opposing this. And so the key to this whole thing is somebody will oppose it because, and they think they can get away with it. The key is to name and shame whoever is involved, because we're living in a world where everyone wants to be ethical and environmentally conscious and racially conscious, et cetera. And to be opposing legislation that would punish tortures and murders is not something that goes well on your ESG scorecard. And so I don't know how transparent the process of lobbying is in Japan, but if you can find somebody who is opposing it, let me know. I'll have fun with that.
Thank you. Anyone else? Yes.
Yes. Of course, and Bill is absolutely right that business is somewhat concerned about Magnitsky law, and so they should be. But they also want to claim that they do care about human rights. So we have to hold their feet to the fire and say that if you care about crime on this sort of scale, then you really have to your laurels and to the. But I wanted really to pick up on one of the chat questions, which came from my friend Mikiko Otari, who is one of my advisors on the advisory council to the Institute of Human Rights of the International Bar. Mikiko asks about, have we considered the impact on children of having their parents on these lists? And of course, Mikiko is a great expert in children's rights, both nationally and internationally. All I would say is, that the children of criminals always, I'm sure, suffer the consequence of having their parents exposed as being criminals. But that's never a reason for stopping the business of dealing with criminality. And one of the things that we have to always have in our minds are the children of those who are the victims of these terrible crimes, and what it's like for them. And so please, Makiko, in considering all of this, do remember that that when we're talking about these grievous crimes against humanity and the people who are enabling them and orchestrating them, there are victims, and it includes children often, but it also includes the parents of children. And so the consequences for families are enormous as a result of these crimes, and you have to bring these people to justice.
Just to follow up again on both what Bill and Helena said very pointedly, and I share what they said, just one case study. Our Raoul Wallenberg Center and myself represent the imprisoned Saudi blogger Raif Badawi, who's in his 9th year of imprisonment. Also some of the women human rights defenders, his lawyer, who's now was sentenced to 15 years in prison, and his sister Samar Badawi, who was imprisoned for calling for the right to drive, a reform that MBS instituted, but then imprisoned the women who called for it. I mean, that's the kind of situation we have. But where we became very concerned is when Saudi Arabia became the chair of the G20. We sought to oppose that. But then when the did not work, but when the G20 did take place this past December, we couldn't get governments to raise the issue of what was happening, the plain and plight of the human rights defenders at Saudi Arabia at the meeting of the G20. Now, it may well be that because it was a virtual meeting, it was harder for them to do it publicly. If it had been a meeting as normally, then on the sidelines, people could have gotten together and made their representations. But the point was the G20 passed without any of the issues of the human rights defenders being brought up from Saudi Arabia. That has something to do, I think, with the business impact, but it has also to do with the reluctance, again, on the high political level, to be as open about it as one should be. And we have been pressing, and with this I'll close, for Magnitsky sanctions for those responsible for these Saudi brave human rights defenders, and those Magnitsky sanctions have not yet been imposed.
Thank you very much. And then I know with the time, clock is ticking, and then I have to hand over to Ms. Professor Kihara-Hunt to close this, wonderful discussion. But thank you very much once again, panelists. But I just want to note before, handing over to Ms. Kihara-Hunt, that there, Professor Igeta has posted that their Export Council of Australia and the Australian Industry Group have come on record to support the Australian government in passing the Magnitsky Act, and then Mr. Henderson has verified that it's correct. So thank you very much. These information are very important. And then before just passing on, it would be really nice that there other G7 countries, who has already introduced Magnitsky-style sanctions, would encourage Japan to also introduce, so that they can harmonize the system. I know that there's going to be another G7 summit, and then if there is statement sessions, whatever meetings on Magnitsky-style sanction, that would be a great incentive for the Japanese government to pass such a law. So anyway, international solidarity, international encouragement, sometimes a little bit of pressure would be very much appreciated from Japan. But thank you so much for all panelists. So I'm handing over to Professor Kihara-Hunt.
Thank you very much for all this information and encouragement for Japan for Magnitsky law. I'm just going to close with MP Yamao's message. We've received a message from MP Shiori Yamao as a representative of a session 2 that will happen tomorrow at 1 o'clock. So if you can follow that session as well, if you are interested in the Japanese movement and Magnitsky law, and that is really the purpose of this symposium, to learn from you all keynote speakers and panelists to enact Magnitsky law in Japan. That would be great. So this is a message. Everyone, good evening. This is Shiori Yamao, member of the Diet and the founder, together with MP Nakatani of the Interparliamentary Alliance in pursuance of introduction of Magnitsky law. Thank you for participating in the symposium on this Magnitsky law from the cases of the world. And thank you organizers for organizing this wonderful symposium. That's a little bit strange to say to myself and ourselves. My remarks are on behalf of the panelists in session 2. As you know, there have been several serious human rights violations in Asia, such as the situations in Hong Kong, Uyghur Autonomous Region, and Myanmar, which are still ongoing. The Japanese government has set dialogue and cooperation as a pillar of human rights diplomacy, but now we may be facing the limitation of pursuing universal values such as human rights or the rule of law if we only rely on the dialogue and cooperation tool. In other countries that share universal values with Japan, mechanisms have been put in place to impose sanctions such as asset freeze and visa restrictions on individual and group perpetrators of human rights violations. Japan, which leads the free and open Indo-Pacific concept, should show the ability to pursue universal values that it commits to by enacting Magnitsky Act. Magnitsky regime is arguably a standard tool for democratic states. Based on this idea, we have been working on various legislative activities since August last year in collaboration with the International Parliamentary League, together with Gen Nakatani and other members of the Diet, and Professor Akira Igata, who is here, I think, today. Professor Igata and other experts and practitioners. I'm happy to tell you that the number of supporters in the Diet is increasing. In session 2 tomorrow, I would like to have a dialogue on the history of the discussion of the introduction of Magnitsky Act in Japan, the points of discussion, and future issues. I hope that many people will be informed of where Japan is at in this movement and work together to move forward. I look forward to seeing you tomorrow in session 2. So that's the message from MP Yamao. And with that, I think we would like to close. But before closing, Haru-san, do you have an administrative announcement about materials?
Yes, thank you. I have for some of you, the email I sent, I don't think you received the files because the files were too big. So I have just uploaded them on the chat. There are 2 infographics. One is in Japanese and one is in English that Paul has kindly made, and some material from Save the Children and also from the Standing Committee on, I think this was Professor Cotler's file. So for those who would like to read on this topic a little bit further, because it is a really interesting topic, please take a look at these materials.
Okay, thank you very much, Haru-san. And this will come to the end of this symposium. And thank you very much for the keynote speakers, panelists. And I would have liked to listen to all your stories much more, and I'm sure the participants are too. But we hope that we will have another engagement in the future and listen to your stories, but also be able to share stories from Japan at the time. So with special thanks to the speakers, panelists, but also to Human Rights Watch and Kanae-san and Mizuki-san, and the Secretariat team, Satoko-san, Paul, Raymond, Chihiro-san, and Meha. Thank you very much, and hope to see you tomorrow. Thank you very much.
Thank you.
Thank you.
So good.